Can you see yourself?
You can admit probably without changing the screen.
Yep.
Sometimes, yeah.
I'll just double check. I'll probably just add everyone, whoever has like one,
Yeah.
rather than just who has a link or registered, because I think that could be the issue.
And save maybe. Yeah. Just another minute.
One minute.
Yeah. Hand up.
I'm doing myself.
Okay, well, we might get started. Welcome, everyone. My name's Carissa Inglis. I'm the Service Support Manager for Queensland Foster and Kinship Care. I just want to start by acknowledging the traditional owners of the land in which we're all meeting today. We are on Turrbal land here in Banyo, and pay my respects to elders past, present and emerging, and extend that to all of our Aboriginal and Torres Strait Islander colleagues online today. We thank you for joining this presentation. Just a reminder to everyone that this is being recorded. Microphones and cameras have been disabled, but the chat function is available, and if you've got any questions, please feel free to put that question in. And I've got Josie and Lisa with me today that will be helping me in the background with some of that technological stuff. Just in respect to confidentiality, because this is being recorded and it will be uploaded onto our website, I just ask that in the chat function, if you have questions, just to keep those questions to general questions only. If you have case-specific information that you have questions in relation to, then please feel free to contact our office following the presentation, and the details of those contact details will be found at the end of this procedure. Just in respect to why we're doing another Standard of Care and Harm Report webinar, because we actually do have one on our website at the moment. The reason we are doing another one is because there has been a change to the procedures since we did that last year. One of the response options has been removed, which is the continue to monitor response. So that's no longer a pathway response, and that resulted as a result of a Standard of Care review project that was undertaken by the department in conjunction with QFKC. And what that project identified is that the continue to monitor response was actually not having the effect that it was intended to, and that really, in terms of that proactive casework, that we need to undertake when we may be a little bit worried about what may be happening in a carer household, or whether they need additional support, is something that we should be doing day to day anyway. We don't need a response or a formal response to actually do that. What we need to do is if we identify as a care team, or if a carer identifies, a worker identifies that additional support is required, to proactively respond to whatever is happening, then we just get on and do it. So that was the main reason why the continue to monitor response was removed. So today we will be talking about the two responses that are left, which is your standard of care review and your harm report. So this will be uploaded, it will be put onto our website afterwards, and we welcome you to use that for carers and for other staff in terms of professional development. So we'll get started.
Apparently there's no audio. And audio isn't clear, it's echoing. So I just opened up.
Okay.
So can you ask them if they can hear you?
Is everyone able to hear me? I think some people are maybe having some audio issues, but if others are hearing us, then I would say that the audio issues are on your end, not our end. Yeah. So if you are having audio issues, it appears it might be on your end, because we've got other participants that are able to hear us. Okay, so we'll get started. If we can go to the first slide. This is what we're going to discuss today. We're going to look at how the department makes a decision in respect to information that they may receive, what the two pathways are if the decision is that they are going to record a standard of care review or a harm report, what the outcomes and actions of those two response pathways can be, what the department's written requirements are, your supports and advocates, and how they can be used in the process, and what the review process is. So that's our content. Okay, so deciding a response. The department receive information, and they have 2 days in which to gather contextual information. So that information can be gathered from a range of different sources. It could be from a community visitor, it could be from a school, it could be from a GP. It can't be from the carer themselves or from the children, because at that point it's considered that an assessment process has begun, but it can certainly involve gathering contextual information from external parties. During these 2 days, the practice manual is really clear that the department must consult with the foster and kinship care agency if applicable, unless urgent action is required. Well, when it says as applicable, what that means is if a carer is attached to a foster and kinship care agency. So the vast majority of our carers are, and so in those instances, it's important that the department consult with the foster and kinship care service. And the reason for that is because the foster and kinship care service will often know the carer more intimately, or the carer household more intimately, than what the department may. And so it's really important that they gather information from the foster and kinship care service to help inform decision making. Now, in that consultation, what QFKC are really wanting the sector to recognise is that that shouldn't just be a consultation that is carer focused in respect to what are we worried about in terms of what the carer has or has not done. That consultation meeting should really be looking at what the whole care team has done or not done that may have contributed to standards not being met for a child. And so, for example, recently in the practice manual, they added that when you are having that consultation meeting, the care team should be looking at things such as whether there is a placement agreement in place and whether it is up to date. And I guess that is essential, because if a placement agreement is not in place, or if a placement agreement is not up to date, or if a placement agreement has not been done in conjunction with the carer, then that very well could have contributed to the situation that you all find yourselves in terms of the standards potentially not being met for children. And the very thing that is reviewed when a standard is not met for a child is the placement agreement. So it's really important in that consultation meeting that you have, where you are sharing information as a care team, that it's not completely care focused, that you're looking at what has other care team members done or not done that could have contributed to potentially standards not being met. So for example, if there is no placement agreement, well then that's probably contributed to standards potentially not being met. But also, if there is a placement agreement in place, but the care team members may not have done what they said they were going to do, for example, referrals to Evolve or things such as referrals to therapy or to a paediatrician, then we really need to be approaching discussions then with a carer that, yes, we're worried that a standard of care may not have been met, but we also, as an agency and or a department, have a role to play in that, because we didn't do the things that we said we would do either, and that could have contributed to the standards not being met for the child. So the focus around standard of care reviews very much needs to be, what is the purpose of this process? The purpose of this process is not a blame-driven punitive approach towards carers. It's actually an approach that looks at how do we ensure that children's standards are met. So the purpose of the process needs to be getting the standards back on track to be met for children. So that consultation process is really important, because that's the beginning of how that process will unfold. So if you have a carer focus that is blame-driven and punitive-driven right from the beginning, then that's going to carry through. But if at that consultation stage, you're actually approaching it as a care team about, okay, what have we all done that could have contributed to this, and what can we all do better into the future, then the focus will actually come onto the child's needs, and the child's needs being met in respect to their standards. So consultation also needs to take place with any other CSOs for any other children in the placement. And like I said, the placement agreement should be reviewed as part of the process in deciding the response. So taking a copy of the placement agreement to that consultation meeting, working through it as a care team. What have we done? What have we not done? And then the senior team leader can make the decision in relation to the recording of a standard of care review, and the service centre manager needs to make the decision in respect to a harm report. Okay, so these are the two pathway responses. Again, we no longer have the continue to monitor response, so there is two responses. One is a conduct a standards of care review, and the other one is recording a harm report and responding with an investigation and assessment. So the practice manual reads that if it is indicated that child's care is not meeting one or more of the standards of care, this response assesses whether the standard of care are being met for the child, and if not, requires that specific actions are taken so that the child's care needs, child's care meets the standards of care. So nowhere in there does it say specifically about the carer. It talks about the care in general. When we look at response outcomes for standards of care, it's either standards met or not met. It's not attributed to a particular person, as with the harm report process. And that was a result of the 2013 review, where it was really important that the department articulated that the standard of care review process is a care team approach, and we're going to talk more about that as we go on. Now, that is different to harm. When there is information that indicates that a child has experienced harm, or it's suspected that they have been harmed, then the response needs to be formal, and it needs to be very quick, and it needs to be very specific in respect to an investigation and assessment style. So if it is indicated that the child has experienced harm, or it is suspected that they've been harmed due to the actions or inactions of their carer, an adult household member or a staff member of a care service, so that's a residential, a formal response is required. So this will determine whether the child has been harmed and whether the standards of care are met and the actions required to meet the child's safety and care needs. So automatically, when the department engage in a harm report, they will all also look at each of the standards of care and whether they are being met or not. So an outcome will involve not only whether harm has been substantiated or not, but also whether particular standards may have been met or not met. Okay, so when we talk about the statement of standards, we're obviously talking about a legislated set of standards around the expected care provided to children and young people in alternate care. And these standards are in place to ensure a high level of care to children and young people who have experienced trauma, so that they can experience an environment that assists them to heal and build resilience. And it is the role of the whole care team to meet those needs. And I think when we think about our own children, if I think about my children, and if I was to, for example, raise my voice at one of my children, because of the stable, secure relationship that I have with my children, because they haven't been harmed, they will recover quickly from that. The impact of raising your voice in respect to a child in care that may not have been with you for long, or that has experienced significant harm in respect to emotional and physical abuse, the impact of raising your voice at that child is much more, and they're not going to recover quickly. So the importance of the statement of standards when we consider why we have them in place for children in care is because we need to provide a high level of consistent care and recognition that we are helping them to heal from their trauma and from their harm. And the way we're going to do that is through the relationship that they have with their primary caregiver. If that relationship with their primary caregiver is consistent and calm and trauma-informed, then they're more likely to heal from the trauma and the harm as to why they're in care in the first place. So if we go on, so again, we need to be realistic though, and we absolutely recognise that carer families are everyday families, and at the moment more so than ever, I think families all around Australia are facing challenges not faced before in terms of the crisis and the cost of living and, you know, the pressures that are put on everyday families in respect to having to do so much. We don't have families that necessarily now that have a stay-at-home parent that is able to do the majority of the kind of the work at home, or one's out working, and that's enough. We need financially to have two people at work, and then the pressure that that puts on the family situation in terms of meeting all those kind of daily care needs of children can just be really high. I mean, we've all got families that are probably linking in and can, you know, attest to the fact that everyday families experience stress. I think when we consider our foster families and our kinship care families, not only are they having to deal with the everyday stress that you and I deal with on an everyday basis, but on top of that, they're having to deal with the pressures that come with fostering. And I know when COVID hit, for example, and I remember saying to Brian, I feel like I had this front row seat into the lives of carers at the moment. I'm having to get permission from the government to go away if I want to. I can't have people in my home that I want to. Like, I just feel like I'm not in control of the decisions in my life. And the difference for me, though, is that that's going to come to an end, and it has, of course, but for carers, that's a life that they live with every day, where they have to have permission to go on holidays, where they need, you know, blue cards for particular people coming into their home for extended periods of time. And so I think, you know, the pressures that we put on foster and kinship care families really need to be recognised in the context of parenting in the statutory system. So in opening up their homes to children, they open up much more. So let's have a look at some of those pressures. So everyday families, of course, we have our financial pressures, we have our parenting pressures, we have work pressures, time pressures, personal relationship pressures, things such as moving home, health, educational issues. We're increasingly seeing carers contacting QFKC and their foster and kinship care agency because they're not able to continue to rent the home that they're in, and they're not able to afford to rent in the same area. We've got carers that, you know, are homeless because of those reasons, and that's a real issue for everyday families currently in Queensland in terms of the shortage of housing and the financial pressures. So when you're caring for a child that has come into care because of a range of different reasons, then the pressure on carer families during these times is exponential. So on top of all of those, we have, again, those financial decisions. So carers are having to already deal with financial stress associated with day-to-day living, but then, you know, as carers, some of those financial decisions are taken out of their hands in terms of if they may want a child to engage in a particular therapy or a particular medical intervention or dental, and that, you know, having to wait for weeks on weeks for approval or not approval at all, you know, so those financial decisions that are out of their hands that they don't have control over. Of course, communication breakdown. I mean, QFKC has been running carer surveys for many, many years, and in terms of the feedback that carers give us about what potentially is not working well, that communication, information, and relationships is always top-notch in respect to the issues that they face. Being unable to access essential health and therapy, you know, we have some carers that are telling us that it's, you know, 2 years down the track, they're still waiting for a paediatric appointment. And that can be, you know, extremely frustrating when they see a need for a child that they're providing care for and it's just not being met. The pressures that come with family contact, particularly for our kin carers, parenting in the system, and of course that fear of accusations. So it's important that we put into context the fact that we are working with families and our response to worries that are not harm-based, so I'm talking about standard of care matters here, should never be punitive or reactive. Rather, they should be seen as a community response that reflects a supportive and coordinated effort to a family in need. So I want you to think about your own networks, and if a family that you were close to, you saw that they were struggling with life. It could be financial, it could be emotional, it could be parenting, it could be a range of things. What we do in those situations is we actually engage to help. We don't, or we shouldn't, respond in a way that makes them feel worse in the situation. And so I guess what I say to you is in our standard of care processes, that's what we should be doing as well. Okay, so when we're looking at the actual process for a standard of care review, that's what we're going to go through now. So a senior team leader makes a decision as to whether a standard of care review will be recorded, and then they plan the review alongside the Fostering Kinship Care Agency. Now, when the procedures changed in 2013, it actually enabled that discussion with the carer to actually be led by a fostering kinship care service worker or the department. And that was in recognition that sometimes the agency worker may have a better working relationship with the carer. And because this is not punitive or blame driven, but it's a discussion to get to the bottom of how we can all meet the standards of care for children, then, you know, the procedure enabled that discussion to be led by a fostering kinship care service. We don't see it a lot, but certainly the procedures enable it. There should be a discussion with the child, and importantly to note, the department should not be using Section 17 of the Child Protection Act to interview the child or have a discussion with the child. That particular section of the Act allows the department to take a child out of a school environment and interview them. And what the reason why it's discouraged in terms of the standard of care review is because, again, we are not talking about harm. We're not saying a child has been harmed, so we don't need to respond in a way that indicates that. When we take children out of classrooms at school to speak with them, children straight away are going to see that as an interview process that could be really triggering for them, because it may be that the last time they were taken out of a classroom and interviewed, they were removed from their birth family or they were removed from another carer. So it's recognising that we don't need to use that section, that we just need to be engaging in a discussion with the child. And yes, that discussion needs to be separate from the carer, so the carer should not be present when that discussion takes place. but it should be a discussion, it shouldn't be an interview, and it shouldn't be, taking a child out of school. Exploring and taking a look at the broader context. So that's what I've been talking about right throughout. This should not just be carer focused. It should be about looking at that placement agreement and what have we done and what have we not done. And if we want carers to sit at a table and say, we could have done that better, then we need to, as other care team members, sit at that same table and say what we could have done better as well. Because our goal needs to be meeting the needs of children. Our goal needs to be meeting the statement of standards. And we all, have our struggles in terms of working in an industry where we feel overworked and don't get to all the things that we want to or should. And so it's likely that there has been contributing factors to the standards not being met by other care team members as well. So we just need to own it, and we need to get it back on track. The goal needs to be meeting standards for children. Now, consideration to section 1224, this is really important. And when I go back to deciding a response, when you're having a consultation meeting, so when the agency and the department are having a consultation meeting about information that they've received, they should be bringing their mind to section 122, which is your statement of standards number 4, which is the application of the standards must take into account what is reasonable having regard to A, the length of time the child is in care, has been in the care of the carer, and B, the child's age and development. So I'm going to give you an example there. If you had child A and he was 10 years old and he'd just been placed with a carer and he had to be taken out of his school because the only placement available to him was, an hour away from his school. The carer said, look, I'm not going to be able to transport the child and keep them in their school, but what I can do is I can keep the child at their soccer club and I can facilitate the once a week training and I can facilitate the game. That's what I can. And that could be the basis on which the department made the decision that that was an appropriate placement, because even though we couldn't keep schooling, soccer was really important to this child, and there's lots of relationships that he has developed in soccer that support his relational and physical permanency. So we've got that child over here. And let's say that this child has, the carer is really challenged by his behaviours. So we're, maybe 5 weeks into the placement, really challenged by the behaviours, unable to kind of manage them. Know that soccer means a great deal to this 10-year-old. So actually says, well, I'm not going to take you to soccer for the next 2 weeks. That's your consequence for not listening to me. So we consider that scenario. So I want you to think about that and keep that in your mind. And then I want you to consider another scenario. So child B, who's also 10 years old and also loves soccer, but he's been placed with his grandmother since he was born, and he goes to the same school, has achieved relational and physical permanency. He loves soccer. Soccer is a great game for him. He's been a little bit of a rat bag lately as well, and his nan says to him, you're not going to be playing soccer this week. That's your consequence. I've tried A, B and C and that hasn't worked, so now you're not going to play soccer. So if we look at those two scenarios side by side, if we apply section 1224 to that, then we would have two responses potentially. So for child A, what the carer has done in that by taking away his soccer is he's actually taken away, his physical and relational permanency connections as well, which is the only ones he's got left, because he's not going to the same school, he's not in his community, so the one thing that he has been taken from him, and the impact on him is obviously going to be significant. Whereas child B over here, the relationship that he has with his nan, the fact that he's achieved relational and physical permanency means the impact of taking soccer away from him for 1 or 2 weeks is not going to be as significant, obviously, as child A, sorry. So I think that provides just one scenario in relation to how we should be considering Section 122. So if you're an agency watching this and you're in a meeting, in a consultation meeting around worries, then I really implore you to have a discussion around that Section 1224. I've been in meetings with regional practice leaders in years gone by where, you know, they've acknowledged that that's not a section that we apply as we should, or that we have a discussion as we should. So it's up to each and every one of us to ensure that those conversations occur in those consult meetings. Now, once all that is done and the assessment is complete, then the department should assess the information and they should consult with the foster and kinship care service again to say, okay, well, this is our assessment, this is what we're thinking, what do you think? And the agency should have an opportunity to respond to that point, and then determining the outcome. Again, when we're determining the outcome, remember we're saying standards are met or not met, and it's about the care team responsibility. So if we go to the next slide, timeframes is meant to be commenced within 5 days, either by discussion with the carer or the staff member. When we say staff member, we're talking about residential services, because remember, standards of care processes also apply to youth workers and residential workers in residential facilities. So commencement 5 days, either through having a discussion with the carer or a discussion with the child. And it should be completed in 4 weeks. And that was a time frame that was created in 2013, and it's not a time frame that's often met. But if we change the way we look at things in terms of the process, then we can absolutely achieve it in that 4 weeks. So for example, if you approach a discussion with a carer from that point of view that I spoke to you about, of we could have done better here too, we haven't done A, B and C, then the conversation starts to focus on how do we move forward and how do we ensure that in the future standards are met for this child. So I've attended a standard of care discussion where very quickly, and I'm talking within the first 5 minutes, it's been established that the standards have not been met for the child and that everyone contributed to that. And we just got on with reviewing the placement agreement, because the focus was about how do we move on to meet the needs of this child. And so in terms of that completion within 4 weeks, it was completed. It was all completed well within the 4 weeks, because the focus was very much about how do we move forward. Now, I need to share with you that some of the outcomes from the project that the department undertook, so they did a whole lot of reads for continue to monitor responses and a whole lot of reads for standard of care review responses, where they read actual case studies throughout the state, randomly selected. And look, I knew that placement agreements were not necessarily being done before a standard of care review had been recorded, or that maybe they were done, but it was a cut and paste from a previous year. What I didn't know is that in 70% of the matters that they looked at, even when the standards were not met, so the outcome was not met, 70% of those cases, they still did not do a placement agreement review. So we had an outcome of not met. So what we're meant to do then is we're meant to review the placement agreement, because our goal needs to be, how do we get this back on track to meet the needs of children? And yet in 70% of the cases, we didn't do that. So then I asked myself, well, what was the purpose of the standard of care review in the first place? So I again implore you that if we are going to come to an outcome that says that standards have not been met for children, then it needs to be purposeful driven and not compliance driven. And if we're purposefully driven, then we will do a placement agreement, we will involve the care team in that, and we will get back on track to ensure that the needs of that child is met. So when we look at the difference between discussions and interviews, a carer should feel the difference between a standard of care process and a harm report process, because they are two very separate processes. Standard of care is about the standards of care that we have for carers that are above and beyond what we have in terms of the general population. Harm is where we suspect that harm has occurred, or we know that harm has occurred, and that harm has to meet the definition of harm under the Child Protection Act. And so it has to be of a significant nature. So it's serious. So when a carer is going through a standard of care review, it should feel informal. The discussion should feel informal. It should be conversation driven, two-sided, and the participants should feel like they're on the same level. An interview process will feel more formal. The department will direct questions to carers and expect responses to those, and there will feel like a power imbalance in that as well. So if we go back to standard of care review processes and what we want to consider as those key concepts, because I just want to really reiterate the importance of understanding the purpose of these processes and not being compliance driven. So we need to think about it being a shared responsibility. When we look at the statement of standards, carers cannot meet the statement of standards in isolation to the care team. They just can't. So if we look at the standards, for example, in relation to meeting medical therapeutic needs of children, in respect to meeting disability needs of children, carers are not able to meet those needs on their own. They need permission from the department. They need referrals. They need assistance and support. They actually are unable to do a lot of the standards in isolation to the care teams. There absolutely is a shared responsibility there. Like I said before, no person is recorded as being responsible. It's either the standards are met or not met. And the letter should, if procedurally a letter doesn't have to be provided, but if a carer would like a letter, then the letter should reflect that shared responsibility. Taking a look at all those contributing factors, like how did we get here and how can we prevent this in the future? And the child has to remain that central focus. So if the child is the central focus, then what our focus is purposeful. And how do we get on and have these standards met, and how can we come together and do a placement agreement that is meaningful and purposeful? That the terminology that we use is not punitive. We should not be using the word breach. We haven't used that word, and nor has it been in procedure since 2013, and yet QFKC 10 years down the track continue to hear the word being used, breach. And what I would say to you is, if you're in a meeting and those words are being used, just to respectfully say, we don't use those words anymore. It's either standards are met or they're not met. It's outcome focused on the whole care team, not on an individual. And like I said, what is our purpose here? Our purpose is to meet the standards of care for children. How are we going to get there? We're going to do a really good placement agreement altogether. So like I said, standards are either met or not met, and if the standards are not met, then of course that placement agreement review will take place. We've been talking with the department actually about reviewing the template of the placement agreement. It's a very old template and we're not sure fit for purpose, so we're starting those discussions, and hopefully into the future we'll get a much better template that is reflective of a carer situation. So it will take a look at what the whole care team needs to do to address the issues leading to standards not being met. And for our foster carers, there is the option for also reviewing the foster care agreement to ensure that it's reflective of the carer's abilities, support needs and learning and development needs. Just a reminder that placement agreements are not if we get around to it, it's a legislative requirement. It is in legislation that placement agreements have to occur, and not only is it in legislation, but it is embedded right through our policy, right through our procedure. In the statement of commitment, it talks about the department's role being to ensure that placement agreements are in place. If you don't have a placement agreement in place, if you're an agency worker and you're struggling to get a placement agreement in place, then I would really encourage you to use the legislation and the policy and the procedure to advocate for those to occur. And if you still don't have any luck, then go and watch our complaints management webinar on our website to look at what steps you can take to get those in place. And, you know, to any departmental workers online, what I would say to you is that, you know, if they're done right, it will save you work in the long run. And I know and I understand that there are so many different, you know, case plans and placement agreements and education support plans and cultural support plans and behavioural management support plans. I get it. But what I would say to you is if we do good placement agreements, then we can prevent a whole lot of instability in a placement. So when we look at the purpose of a placement agreement, it outlines the goals of the placement. It provides relevant information about a child, and it records the agreed support and services to be provided to the carer or care service. So it's really individualistic. It's based on, you know, that carer household and that child and what their needs are in order to bring about placement stability and ensuring that the needs of the child are being met in line with the statement of standards. So the practice manual outlines that a placement agreement will be informed by all of the following. So the strengths and needs of the child, the assessed level of support needs, including behavioural support, what the case plan goal is and outcomes and actions, financial supports, information required for the child to be up to date with the immunisations, and if not yet incorporated the case plan, details of child health passports and education support plans. Information about child safety records, including details of previous placements, for example, frequency, reasons for placement breakdowns or their relationships with children in previous placements, including incidences of conflict or bullying, and previous suicide risk alerts, suicide risk management plans and related outcomes. Information provided by agencies involved with the child, including specialist services such as Evolve. And I just received an email last night to say that there has been some updates to the practice manual to include assurance within the placement agreements around Aboriginal and Torres Strait Islander children and how specifically their cultural needs are being met in terms of the 5 core principles. So what happens if we don't have placement agreements? Well, we get increased traffic to service centres because carers are not sure about what it is they should be doing. They don't know about family contact arrangements specifically, or they're needing to get permission for financial support, or they're wanting respite, or, you know, all those things that are captured in a placement agreement. If a carer doesn't have a placement agreement, then they're going to have to contact the service centre to find all of those individual things out. They may not adequately be informed about a child or young person's needs. So remember, in the Act, we've also got a section that specifically talks about the information that needs to be shared with carers around a child. And so when we're doing a placement agreement, we can refer to that section of the Act to ensure that the information that we're sharing with a carer is relevant and that they have all the information that they need in order to provide safe and stable care for a child. Not only in respect to the child, but also other family members that they have.
I have one question.
Okay, so we've just got a question. Yeah.
Sorry, how often do they need to be done in terms of the placement agreement?
So placement agreements should be done every 6 months, or they can be done at other intervals if there is a change in circumstances in a family, in a carer family. So, for example, if you had a carer family member that got sick, then you could request an updated placement agreement because the needs of the household have changed, but they should be otherwise done every 6 months. Could you just go back? So increased chance of standards not being met for a child or young person when we don't have placement agreements in place. Educational, health and cultural needs not being adequately met because those are all areas that are explored in a placement agreement. Potential lack of shared understanding of all the matters relating to the placement. So, for example, financial and expectations of family contact, lack of understanding regarding support needs for the carer, and instability and possible placement breakdowns. So we're going to get onto harm reports now, but I just want to really reiterate, you know, the key messages in respect to that standard of care process. Shared responsibility, make sure you do placement agreements, keep your focus on the child throughout that process, and be prepared as care team members to stand up and say when you could have done something differently or where you may have contributed to the standards that not being met, to sit at that table and say, look, you know, I haven't done a home visit in 6 months or 3 months or 2 months, or I didn't complete that referral to Evolve, or I told you I was going to get training for you in respect to this. And, you know, acknowledging that when that stuff isn't done, that also contributes potentially to children's standards not being met. So we all have a role to play, and the standards cannot be met in isolation to the care team. So we're going to get on to harm reports now. So harm report process, the manager needs to make a decision as to whether a harm report is recorded or not. And given that we're saying that a child has been harmed, or it is suspected that they have experienced harm, and that definition of harm is the one under the Act that talks about harm being of a significant nature, we absolutely must respond very quickly. So child safety have 24 hours in which to respond, and in that time a child must be cited. Child safety must still consult with the foster and kinship care service, but I want to be really clear here that consultation might take place after they've already recorded the harm report, because the focus obviously needs to be on ensuring the safety of the child. So if the information that the department has received is clearly indicating that the child has been harmed, then they just need to respond to that and ensure that the child is safe. So the consultation with the agency might come after the fact, but the consultation should still take place, because again, the agency might have some contributing information. Harm reports cannot be raised on risk of harm alone. Now, I just want to be really clear that doesn't mean we don't respond to risk of harm. It's just that we don't raise a harm report on that. So an example of that is if a carer, for example, said to an agency worker, my new partner has just moved in and they can't get a blue card. Because, you know, they've been accused of doing things in the past, but I don't believe it, and, you know, I'm confident that they're going to be safe around children. So in that instance, you don't raise a harm report because it's risk of harm, but you absolutely respond. And so in that instance, you would be saying to the carer, he moves out, or we need to take the children. So it's not that we don't respond to risk of harm. It's that you don't need a harm report to respond. So another example I'll give you is we had one many years ago where a little boy kept on opening up the back door to go outside, and he would be found, you know, wandering the streets at night while everyone was in bed. And so there was a risk of harm to him. He could have been taken, he could have been run over. There was a whole lot of things that could have occurred, but harm didn't occur to him. And what we need to do in that situation is we need to respond to the risk of harm. So how are we going to keep him safe and secure in the home? And that needs to be our focus. So that gives you a couple of examples there. So an interview will be conducted with the carers and children by child safety. So agencies can't drive a harm report process. They have to be driven by the department. The department will interview the children, and they will interview the carers, and they are able to take a child out of school and interview them under that section 17. They still have a responsibility to assess broader context. It's important that that occurs, and there's a 6-week timeframe to conduct the investigation. So what to expect? A harm report has been recorded because child safety have assessed that harm has occurred, or it's suspected that harm has occurred, and that this harm meets the definition of harm under the Child Protection Act. Carers may not receive a letter immediately, but the department are required to provide you with a letter at the time that the harm report interview takes place. So there are going to be occasions where you attend a harm report interview and the only information that has been shared with you is that a harm report has been recorded and that they need to investigate in relation to that. Now, the reason why the department may not share information with you about what that harm is about is because it could compromise the investigation, or it could put a child at risk. So they're not obliged to provide any information to you in advance. However, at that harm report interview, you should be leaving that interview with a letter that clearly outlines what the allegations of harm are. And of course, you've been in the meeting so that in that interview, and so the department would have put those allegations to you to respond. They'll also speak to you about what standards they are also looking at in terms of the investigation and assessment process. An INA team, so the investigation and assessment team, will undertake this process. It is formal and it will involve interviews. Carers should be advised that in a harm report interview that you are able to record the interview. Now that's really important because there needs to be one accurate record of that harm report interview process, and the consequences for harm report outcomes can be dependent on the concerns, obviously, and dependent on the outcome. But children can be removed, carers can lose their carer certificates of approval, carers can lose their blue cards. And so it's important that we treat this process as a very formal process that can have outcomes that are life-changing for many people. And so that opportunity for a carer to interview, to have the interview recorded is one that should always be provided. There's guidelines in the practice manual that outline what advice should be given to a carer around that. But in summary, it's important to know that that recording cannot be shared with anyone other than potentially in a QCAP proceedings or in a review process, and the recording is subject to the same confidentiality provisions that we're all under. So, you know, carers are not able to go and share that interview with friends or family. It is about using it for the purpose of any particular review processes that might come after the fact. What's important also to note is that when harm has been recorded, the department have a threshold in which they have to refer matters to Queensland Police, and Queensland Police will make a determination as to whether they will investigate and assess potential criminal charges in relation to the allegations. Their process will take precedence over the department's process. So what that means is, if Queensland Police say, yes, we're going to run with this, then the department's process has to go on hold, because the criminal process is, you know, obviously takes precedence, and they need to complete their investigations and assessments and determine whether charges are going to be laid. Now, carers often think that if the police say, oh, well, no, we're not proceeding now, we don't have enough, or we have decided not to go any further, that means that the department will also have an unsubstantiated finding, and that's just not the case. So what we need to recognise here is this: Queensland Police have a burden of proof of beyond all reasonable doubt. So if they decide to lay charges in relation to the allegations, what they need to be satisfied of is that if they take this to court, that a jury of your peers will find beyond all reasonable doubt that the allegations are true. So that's the burden of proof that Queensland Police are going by. Whereas in terms of the department's outcome of harm, that what they're looking at is probability and likelihood of whether harm has occurred or not. And so they don't have the same burden of proof, and they will use the information that they have and place a lot of reliance on what the child has said and what their disclosures has been, because it has to be child-centred. And so it's really important that carers understand that just because a police might not pursue an investigation and assessment, it doesn't mean that we're not still going to have a substantiated outcome of harm. So it's important to also recognise, like I said, that you might have your harm report on hold for weeks at a time while the police decide what they're going to do. Now, in terms of what carers can do in that process, is carers can contact Queensland Police directly when they know that a referral has been made to Queensland Police, and you can ask to speak to the person in charge of the investigation for updates. So that's something that you have control over, and they may then tell you, no, we're not progressing, so you can feed that back to the department, and obviously Queensland Police will as well, which means that the harm report process can now begin. So what are the outcomes of harm? So these are the outcomes that can be reached. So unsubstantiated harm standards met means that we've looked at the allegations, we've not substantiated harm, so harm has not occurred, and the carers have met their standards of care as well. So nothing has happened to the child. Unsubstantiated harm standards not met. So that outcome is we don't believe that harm has occurred, so it hasn't met that threshold of significant harm, but our investigation and assessment has determined that there has been some standards of care that have not been met. Substantiated harm standards met, that can be a really confusing one because that's telling us, well, harm has occurred, but the carer has met these standards of care. So the easiest way of describing that one is when we looked at the definition of harm to start with, we talked about whether the actions or inactions of carers have contributed to that harm. So you might have a situation where an adult household member has harmed a child. And so in that investigation and assessment, what the department will be looking at is not only what has occurred in respect to harm, but what were the actions or inactions of the carer that may have contributed to that. So in the event that they feel that the carer had all of their safety precautions in place and, you know, this was something out of their hands, then it would be substantiated harm but standards met. So that the actions or inactions of the carer has not contributed to that harm. It's separate to that. So that's your standards, substantiated harm standards met. Your substantiated harm standards not met is harm has occurred and standards have not been met as well. So that's, you know, the final outcome there. There can be a no outcome. I've not seen one of those before. It can only occur in exceptional circumstances and must consult with the senior prac. So that could be an historical harm report potentially where, you know, the children are not able to be interviewed or the carers are not able to be interviewed. Like I said, I've not seen it in my time. It's not to say it hasn't occurred, but that's one outcome. So action plans. So with those outcomes that I just read out before, action plan would be developed in, can you just go back, Josie? I'll tell you which ones. So unsubstantiated harm standards not met, an action plan would still be developed for that one. So that's second outcome. And the other outcome, the other action plan would be substantiated harm standards not met. So in those standards not met one and substantiated harm, that's when an action plan would occur. So child safety has 6 weeks to complete the investigation and assessment, including the development of the action plan. So technically, that 6 week time frame that has been provided in terms of the investigation and assessment should also be inclusive of having an outcome and developing the action plan. It doesn't really happen in that way, but that's technically what the practice manual talks about. When developing the action plan, this should be inclusive of all care team members. So it should never be a case of a carer receiving an action plan in the mail or via email. It should be a situation where all care team members come together and talk about where to from here. I think what I need to be really clear about as well, can we just go back to the other one also? Because not always will an action plan occur when there has been substantiated harm, because the department may have reached a conclusion that the carer may not be suitable to be a carer anymore. So there's going to be occasions where action plans are not entered into because the department's course of action will actually be to propose to cancel the carer's certificate of approval or to have the carer undergo a suitability review. So in those instances, the department won't engage in an action plan straight away. So carers should be told though. So when a carer gets their outcome letter to say harm has been substantiated, it should also say in that letter what the next steps are going to be. So are the department going to engage in an action plan with the carer, or is the department's view to do a proposal to cancel, or is the department's view to do a suitability assessment? Now, in terms of a suitability assessment should only ever be done where the department are considering that they may still be suitable. We should not be putting carers through suitability assessments where the department have already reached a determination that they are no longer suitable. If the evidence in the outcome of the harm report indicates that the carers are not meeting legislative requirements to be carers, then they need to follow a process of a proposal to cancel and go down that route. And a suitability review should only take place where a manager is genuinely considering whether the carer could go on and be a carer or not. And a suitability review usually comprises of an external assessor being given terms of reference to actually undertake an assessment around a carer's ability to continue to meet the statement of standards and the legislative requirements and policy requirements to be a carer. Okay, so if we go through, can I just go back to the action plans? What's really important with action plans as well is that they need to be achievable. So if you're engaging in an action plan, either as an agency worker, a department worker, or a carer, and things have been written down. So for example, if it's been written down that a carer needs to do trauma-informed training, it's important that it's identified which trauma-informed training, when is that on, who's going to facilitate it, and then who is responsible for sitting down with the carer after the training to go through their learnings and reflections on that. So it shouldn't, and I'm going to use that purpose versus compliance again. We need to think, what is the purpose of these action plans? It shouldn't be compliance driven. So any actions that are actually written up should have a purpose behind them, and there should be a review process in place to ensure that whatever is behind each of the purposes for the action plan is achievable and is reflected upon. So if additional concerns come to the attention of child safety during the course of a standard of care review or harm report, these concerns must be raised with the care team, including the carer, and they must have an opportunity to respond. A carer should never receive an outcome letter that has new information in it that they have not had the opportunity to respond to. So even if it's in, 5 weeks into the investigation and assessment, let's say someone else was interviewed and new concerns arose, you actually need to go back to the carer and interview the carer again and put those concerns to them and give them an opportunity to respond. An outcome letter should never have an outcome that is reflective of information that has not been explored with the carer. The other information which is important to understand is that standards of care, so when you have your consult meeting and you're deciding as to whether to record a standard of care or a harm report, it's important to understand that a standard of care review can be upgraded to a harm report if during the course of the process you identify harm has occurred, but a harm report can't be downgraded to a standard of care. So my advice in that consult meeting is, if you're unsure as a department or agency whether it does meet that threshold for harm, then engage in that standard of care review with the knowledge that you can upgrade it if needed. The additional concerns are to be assessed in conjunction with the original concerns. So outcome advice, child safety are not required by procedure to provide letters to carers for a standard of care review, either at the beginning or at the end, regardless of outcome. It can get really confusing in this space, because all the foster and kinship care agencies online are probably thinking, your HSQF requirements have an expectation, and that's where it's really difficult that sometimes departmental policy and procedure and HSQF requirements don't align. But technically speaking, the idea behind this, I was involved in the 2007-2013 review. And the 2013 review in respect to standards of care was really meant to be about not having it as informal and that shared responsibility. And part of that was like, well, the moment we start putting things in writing is when we start to formalise it. So the idea behind not having written outcomes was to reflect that we weren't trying to engage in this really formal process. Unfortunately, what's occurred over time is it is still, been treated as a formal process, and letters are often requested and wanted by all of those involved. But like I said, if a letter is going to be provided, then we all have a responsibility to make sure that that letter is reflective of that shared responsibility and that it's not just carer focused. Birth parents are not required to be advised of a standard of care review, either in writing or verbally. With our harm report, Child Safety are required to provide those letters to carers and agencies, and it should outline the alleged harm and what standards Child Safety believe may have not been met. They are then required to provide an outcome letter to the carer once the investigation is completed, and Child Safety are required to advise the birth parents of the alleged harm. There is some discretionary ability there in terms of advising birth parents, but you know, there'd need to be a good reason as to why they weren't sharing information with the birth parent about harm, and that goes way back to the CNC days. Where carers were not, where parents were not being informed at all in relation to any allegations of harm in respect to their children in care. So a recognition that they have a right to have that information. Okay, so support people and advocates. What's really important to understand is that we as a department, we as an organisation, QFKC, we will call ourselves advocates in a harm report meeting or in a standard of care meeting. And that doesn't mean we're there to advocate whether the carer has or has not done what is alleged to occur. That is not our role. We will never do that. But it is our role to advocate that the process is fair and just. So we will do things such as ensure that the carer has the knowledge that they can record it. We will ensure that the carer's voice is heard and that the procedure, so the standard of care review procedure and the harm report procedure, are being followed as they're intended to be. So our advocacy is around process. So in terms of a support person, a person is known and trusted by the carer who they choose to support them during the process. A support person doesn't speak on behalf of the child or parent or intervene in or influence the investigation and assessment. The advocate is there to ensure the fair and just process. So they're not there to defend the carer or speak on behalf of the carer in relation to the issues being discussed. They are there to ensure that the process is fair and just. So it may be that, so for example, you might be in a harm report interview and the carers had their response, and then the department might say, right then there, we will be substantiating, for example. As an advocate, it would be appropriate for me to say, but the carer has provided a number of other external parties that they want you to interview as part of the investigation and assessment. So we would be asking you to undertake those interviews with those external parties before you came to an outcome of substantiated harm. So in that instance, that's an example of QFKC advocating a process. We're not saying whether it should be substantiated or not. What we're saying is that a process has to be followed before you reach that outcome. So if carers are not happy with the outcome of either a standard of care review or a harm report, they can request a review. So that should always be in the letter, particularly for harm reports. So either the senior prac from the office they're attached to or an independent senior prac or sometimes a regional practice leader will conduct the review. It's really important that if you're requesting a review of a harm report or a standard of care, that you're able to identify what it was about the process that you don't feel was fair and just. So was it that there were people that were interviewed, people that weren't interviewed that should have? Do you feel that you weren't provided with an opportunity to respond appropriately? Do you feel that you have more information and that you put yourself forward for another interview and that was rejected? Were there children that should have been interviewed that weren't? You know, what was it about that process that you feel that a review would actually succeed in having potentially a different outcome because the process wasn't fair and just? So we need to remember that it takes a whole care team to meet the statement of standards for children and young people. I really want you to take that message away. Carers, like I said, they actually can't meet the standards of care in isolation to the care team, just like they can't meet the child rights in isolation to the care team or the human rights. We need to remember that our wonderful carers online are everyday families that are volunteering their time. We have way more fostering children in residentials than what we did 3 years ago. And that needs to change. We want every child in care to have an irrationally crazy person about them that is going to be their advocate, that is going to be their person in their corner, that is going to be that person that they have, you know, when the care experience is finished. And so we really need to value our foster and kinship carers and recognise that we want children to be in family-based placement, so we have to get our processes right. So our job is to surround the carer family with support to help them be the best that they can be. So those are our contact details. We've still got fast reps up there, but they haven't been fast reps for over a year, so I need to change that. They're called our QFKC support team members. So if you need advice or support, we have our Brisbane office. We've got 5 case officers based in Brisbane, and we have 1 case officer based in Townsville. So we are available to provide support and assistance through standard of care or harm report matters. So that's the end of the presentation. We've got some time for questions. If anyone has any questions that they would like to put into the chat. Just remembering to just adhere to the confidentiality provisions and not provide any specific information. Just give it a minute to see if anyone puts in any questions. If you don't have any questions, you are free to go now. And yeah, we thank you for linking in today and being part of today's webinar. We will have more webinars up ready to go, you know, towards the end of the year. And we're open to suggestions. If anyone out there has suggestions about what you would like to see webinar on, then, you know, by all means, just email the admin email up there, admin@qfkc.com.au with any suggestions, and we'll see what we can do.
Okay, so we do have one. So can they get a copy of the slides that you've done today?
Yeah, so the slides will actually be, when we upload the recorded webinar today, the slides will be uploaded as an attachment to that as well, so you can download them on our website. You'll also be able to download a certificate, and you just need to put your own name into that, but there will be a certificate template on the website as well. Just give us a week to get it all up and running.
Another question is, if the carers decide to resign in the beginning or during the harm report process, will the process continue?
So the question was, if a carer resigns during or before the harm report process, will it continue? So typically, yes, it will, and without the responses from the carer, then the department will come up with an outcome that is reflective of that. So they may choose to substantiate harm because the information that they have supports that, and without an interview with the carer, then, you know, that's all they've got to go by. Like I said, in those rare situations, they might have a no outcome, but that needs senior prac approval. What I would say to carers is really encourage you, if you're going through a harm report process, to actually have your say, because, you know, these processes can impact on blue cards. And so if blue cards did request child protection information on you, and the department provided that, and it was only one-sided in terms of the department's assessment, but did not include your response, then that could have a negative impact potentially on you retaining a blue card. So I'd always encourage carers to see a harm report process through.
So what happens if the department does not meet the timeframes?
So if the department do not meet the timeframes, the practice manual says that you are able to request a letter from the department outlining why there has been a delay in the process and an expected timeframe as to when it will be completed. So you have every right to do that, and we do that at QFKC all the time. So, and it really just holds the department to account to timeframes. So, you know, we've now gone past the 6-week timeframe for the harm report outcome. Can you please provide a rationale as to why, and could you please provide an updated timeframe as to when we can expect an outcome, as per the practice manual?
If the SOC process is not being formalised and team focused, does this mean that it will not be recorded or reviewed in the care renewal?
So just repeat that.
Yeah, if the SOC process is not being formalised and team focused, does this mean that it will not be recorded or reviewed in the carer renewal?
No, once a standard of care is recorded, then the standard of care process will be on the department's ICMS or Unify, and then it will, in your renewal of approval, it has to record whether there's been standard of care processes or harm reports. But I'll go a step back, because what I would say to you is that if you feel that you've been involved in the standard of care process that has not been consistent with the procedures, that's when you should be requesting a review of the outcome. And any review process, so then let's say in the review that there was a finding that the department didn't do what they should have, and there should have been, further information sought, or that the care team did contribute to the standards not being met, then that should be recorded in the carer renewal in the section around standards of care, that yes, there was a standard of care review recorded, the outcome was standards not met, the carer sought a review of this for these reasons, and this was the outcome. I hope that's answered your question.
The next question is, should the carer always be alerted of a SOC, or could it go through without their knowledge?
So should a carer always be alerted about a standard of care, or could it go through without their knowledge? Carer should always know when there's a standard of care. And in terms of the process to plan the review, it shouldn't be a matter, it's different. So with a standard of care review, you shouldn't just turn up to the department, or agency shouldn't just turn up to you with the department to say, oh, we're here to just talk about a standard of care review. There should be a phone call that says a standard of care review has been recorded. We would like to have a discussion with you. And so that should be a planned process. We are not talking about harm. Now, one of the reasons why the continue to monitor response was taken out as well was because that was happening a lot, where carers were only finding out about the fact that there had been a discussion and a response recorded around a continue to monitor, and carers were only finding out about it in their renewal of approval. And that was never the intent of a continue to monitor. It was always about, okay, we need to kind of come in here and do some proactive casework, and we're going to take the carer on that journey. So the answer to your question is, carer should always know when there's been a standard of care. You always need to be part of that process and any outcome.
So are standards of care reviews only triggered if a carer has not met standards, or could actions or inactions from the care team trigger the SOC review?
Yeah, that's an interesting question, and it's asked when we do this training a lot, saying, okay, well, a standards of care then only triggered when it's felt that a carer is not meeting the standards of care. What I would say to you again is purpose. We need to be purpose driven. So as carers, if you are sitting in a space where you do not believe that standards are being met for children in your care, then I would be saying, I want a placement agreement review, because that is the document that we go to when we are worried that standards are not being met. So you can say in writing, I am worried that the care team is not meeting the standards of care for the children. These are the standards that I don't think are being met. I would like an updated placement agreement review with the department and the agency present to work on how we can move forward in meeting the standards for the child.
Yeah. And could a standards of care review be a way of encouraging team approach if other avenues have not worked?
Yeah, again, I think if the intent of a standard of care review when we reviewed it in 2013 was really about getting things back on track for children, and acknowledging where things had fallen down in respect to the standards. And so it can be that if we look at it from a strength-based perspective, it can be that point in casework activity where we recognise, okay, we need to do better. And having a standard of care review can bring about those discussions, and then, become really solution focused and child focused on, right, and what do we do about that? Having the placement agreement reviewed and being really specific about, okay, well, what standards we were worried about and what are the actions that we all need to engage in to ensure that into the future that those standards are going to be met.
All the questions.
I hope that's answered all the questions. That's all the questions that we've got listed at the moment on our chat. So once again, I just want to thank everyone for your participation. I hope that's been useful. We do have a bit of a good news story where the previous one webinar that we had up of our standard of care, a carer was encouraged to watch that had contacted QFKC because they were going into a standard of care review. And they felt really empowered going into that review afterwards. And the outcome was a really positive outcome with recognition from care team members that, yeah, they had contributed to the standards not being met for a child, and it became very child focused and solution focused, and most importantly, child focused. Yeah. One more question.
So what if an adult household member is taking care of a child in care for a period of time and standards of care were not met, but not indicating risk of harm or harm level?
So potentially, so that's around a household member. And if a household member is not meeting the statement of standards, then, but there's no harm indicated, what can occur there? Because again, we need to be focusing on, the focus is about not who, but what. So if that indicates, so if a child's standards of care are not being met, then a standard of care process should still be initiated. And then the placement agreement will be looking at what's led to this. Is it that if we're leaving a child in the care of a household member that has been approved, but may not have done trauma-informed training, like, is it that we need to get more training in for that household member? What is it that we need to do to ensure that going forward, that any household member that has been approved to care for this child is in a position to meet their standards of care?
There's another one. So what is a carer nan meant to do if a 7-year-old grandchild who is in care has escalated behaviour in car travelling on the motorway, while 2 other young grandchildren are also in the car, an adult son also in the car, while travelling from A to B?
Yeah, look, that's more of a specific question around a circumstance where, you know, we have children in a car escalating, and, you know, what a carer should do in those situations. For the person that's written that, I just encourage you to contact our office and us to speak to the on-call worker, because we need to provide, we can't provide general information in respect to specific cases. Yeah, so just encourage you to contact our office and we can talk that through with you.
And that's all the questions.
That's all. Okay, once again, thank you everyone. We'll end today's session, and if anyone thinks of any other questions, please feel free to contact our office after today's session is finished. Thank you. So we can probably